Welcome, everyone. It's always exciting to have lunch with Liz, and here we are in 2025. Welcome to the new year. My name is Liz Moneymaker. I practice law with estate planning, so think things like trusts and wills and powers of attorney and living wills, those types of things. I also do probate and trust administration and Medicaid planning, and I do that here in St. Petersburg, as well as virtually throughout the state of Florida. So today's topic is getting organized in 2025. What steps do you need to take to ensure that you either A, have an estate plan, or B, have, if you already have one, make sure that it is the right one for you and it's working for you currently. So I'm going to break this up into sections. The first section, I'm going to talk about um, things that you can do yourself, that you don't need a lawyer for. And then after that, we're going to talk about if you either don't have an estate plan, what you need to do. And then if you already have an estate plan, some things that I suggest you do going into 2025 to get organized. Okay. So the first part of this then is some things you can do yourself. Let's get out your to-do list and we can just start filling it up right now with some steps I think that you should take starting in 2025. The first thing is to check your beneficiaries on your accounts. So we're talking about that IRA you had from two employers ago. We're talking the 401k that you've had from your current employer for 20 years. We're talking about life insurance policies. We're even talking about things like checking and savings and certificates of deposits and brokerage accounts. All those can have beneficiaries attached to them as well. We call them something different. We call them pay on death designations or transfer on death designations. But one of them, the main things that you should do is make sure that all of those beneficiary forms are correct. So if you've divorced, if someone has died, if someone has grown out of favor from you, since you have filled out those beneficiary forms, you're going to want to put a new beneficiary form in place. Another thing, and I know you're not going to believe me when I tell you this, but those forms get lost. So if you filled out the form 5 years ago with your employer or at the custodian of your retirement account, those companies get bought, those custodians of the IRAs, 401ks get bought, and paperwork gets lost. So taking the step to ensure that your beneficiary is properly in place also ensures that you have a beneficiary form there in the first place. And you're like, well, Liz, big deal. Why is that important? Well, it's important because when you have a beneficiary placed on these accounts, it bypasses the probate process. And that asset, whether it's your IRA, your 401k, your brokerage account, your checking account, if it has a beneficiary on it, it's going to go to that beneficiary directly after you die. There's not going to be a judge involved, a court involved, like what the probate process is. So if you have a beneficiary form out there and the person on that form is dead, or you don't have a form in place out there, then that asset unfortunately has to go through probate, which 99.9% of the time means your loved one then has to hire a lawyer, has to open up a court case, and they won't see that money for 10 to 12 months. And then part of that money is going to be used to pay for lawyers. It's going to be used to pay for court costs. So that's your motivation to put this as one of your to-dos on how to get organized in 2025, is making sure that those beneficiary forms are accurate and that they're in place. Okay. Next thing, and if you have questions about that, again, there's the chat app, which I will check occasionally, and if I miss it, my assistant Vicky's on here, and she'll draw it to my attention. And you can also just holler out at me, like and we'll roll with it. Because like I said, Lunch with Liz, to me, I created it to be a conversation, and a give and go. So don't hesitate to do that. So we're talking now, if some of you have come in a little bit later, we're talking now about some things that you can do yourself without a lawyer involved. And the first thing we talked about is checking and making sure that you have those beneficiary forms in place. The next, and I know I'm going to bum you out when I tell you this next one, so I'm going to apologize in advance, but create, if you haven't, and make sure it's accurate if you have your funeral and burial plans. Ah, I hear it. I hear the groans. I hear the groans, even though you're all on mute. Nobody wants to do this, right? We don't want to think about our mortality. But it is, speaking from someone that deals with this on a daily basis, it is one of the greatest gifts that you can give your loved ones, your partner, your wife, your husband, your children, is what are your wishes? Are they put on paper? Who's responsible for your ashes if you're getting cremated? What do you want to have happen to your body or your ashes? Not putting this in writing and not talking to your loved ones about it can create a lot of animosity, especially if you're in a blended family and you are with a partner, that partner has children from another relationship. There can be a lot of tension if things aren't already put down on paper. One of the other things that you can do, and that's also in the same realm that's a gift, is prepaying for your funeral plan. It's less expensive to do it in advance, and it's one less thing your loved one has to worry about paying for and figuring out how to do. Um, I love the Cremation Society, if that's where your route is. But almost any funeral home will do the prepaid stuff. Um, again, again, I probably should have put this at the end, not to bomb everybody out at the very beginning, but it is an important thing to think about. And I think we had a question about that. Um, Herb says, would 5 wishes be something to use to help your family know your wishes? Absolutely. 5 wishes is one of those things it just kind of walks you through some of the decision making. If you're my client, you get a remembrance and services document to fill out that helps walk you through those issues. Um, we have a question. I'm a registered organ donor. Do I still need funeral plans? Absolutely. Um, my my nephew was killed in a car accident, and he was an organ donor. We still had to have plans for what to do with the body once the organs are taken. So you still would want to have those funeral plans in place for sure. Great questions. Thanks for asking, and keep that up as we go through, because again, that's the whole point of this. Is you didn't sign up for a lecture, I don't think. So please feel free to have that give and take. So far we've talked about 2 things that you can do without a lawyer even getting involved. That's updating all your beneficiary forms on your accounts and then creating or updating your funeral plan. The next thing, and I guess I am just intending to bum you guys completely out during this lunch with Liz, and that is, what's your plan for long-term care? Statistics say most of us, I believe the latest statistics we have out now, it's almost 70%. I think 66, 67% of us are going to need some sort of long-term care. That could be in the home, that could be in assisted living, that could be in skilled care, which is what we call nursing home. What's your plan? What's your plan to pay for it? If you're of a certain age and of certain health, you might be able to get long-term care insurance. So that's something to explore. There are also life insurance policies with long-term care riders. That's something to explore with your financial advisor. Or are you thinking that the government is going to pay for your nursing home care? Keep in mind that Medicaid day window that it will pay for in a rehab situation. But for long-term uh, care, Medicare does not pay for it. The federal program that pays for long-term care is called Medicaid, and there are asset and income requirements when it comes to who, well, if the government will pay for your long-term care. If you are, I don't know, I would say between 65 and 70, or earlier than that, if you have health issues like Parkinson's, early onset dementia, those types of things, you want to go talk to a lawyer to do some Medicaid planning because we can help protect assets for your spouse or for your children if we can proactively plan for that. So that's the third egg here is planning for your long-term care. I think we had a question. Um, okay, I don't think we do. That was a comment there. So thanks for that. Thanks for being some active in the chat. I like it. Okay. So the next thing to do, and again, we're still talking about the things that you guys can do without me, to help get your affairs in order, as we like to say in the biz, and that's inventorying your assets. And I know you're gonna like, Liz, come on. I can just tell you my assets off the top of my head. I can tell you how many clients come in, and when I start asking the questions, they don't know the answer to these questions. Christine's raising her head. Yeah, yeah. So first thing, whether you are trying to be a DIYer or you're going to go talk to a lawyer, get it down on paper what you have. What real estate do you have? Like I'll have clients that'll come see me and we'll have an in-depth intake, and then they'll call me up. Oh yeah, we also have that lot in Oklahoma I forgot about, right? So what real estate assets do you have? What vehicles? What toys? RVs, boats, jet skis, motorcycles, um, jewelry, art collections, collectibles. You know, your Fred Flintstone collection could be valuable to somebody else. So you want to write that down so that we can talk about it when you come in for your consultation. And then, of course, all of your financial assets. And this can be kind of wonky for some people who maybe had multiple jobs. So they have multiple 401ks that they have sitting out there. So you want to have a list of your stocks, your bonds, all of your bank accounts. Some people have 4, 5, 6 different bank accounts. And I'm not even talking about business accounts, I'm talking about personal accounts. If you're like my mother-in-law, she's going to go open up one every time they're going to give her a free $50. So she's got multiple ones all over the city of Gulfport for sure. You know, what pensions do you have out there? Yes, pension. Are you one of the crypto people? You know, we need to know all of this because in order to have a holistic plan that's going to work for you, you need to know what you have because we need to know what you have to know what's the best way to dispose of it when you pass to hopefully avoid probate. And I'm going to pause there because I think we might have a couple of questions. Yeah, a pension is considered for this. I would want to know that. You would want to know that. Because when you think about a pension, some pensions they have a survivor benefit to a spouse. So we would want to know that. We want to make sure that the spouse is on file, that we understand how to make that claim when someone passes. So definitely a pension is on the list of things that you would want to have on your inventory list. Question from one is, if only real estate assets, can we just do a ladybird deed? Well, I'll talk about that later when I'm talking about estate planning. Maybe a ladybird deed is a good thing for you, and maybe not. Peter asked how to protect assets in case I have to go to a nursing home. I don't know what government entities pays for what, if any. We're not, I'm not doing a Medicaid seminar today, but that is one of the things you would want to talk to your attorney about when we get to the part today when I talk about things you need an attorney for, that's one of them is how can you do Medicaid planning so that you can protect your assets in the event you needed to go into a nursing home for sure. So, in order for an attorney to be able to advise you on that, you need to take this step, which is what do I have? What bank accounts? What's in them? You know, what is my brokerage account worth? What taxable accounts do I have versus non-taxable accounts? If I don't know what that means, then maybe I need to do some homework about knowing what the difference between a taxable account and a non-taxable account is. This is important for many reasons. One, so you just know what you have. Two, so you can get advice from a financial planner or an attorney. Three, so you can know what tax implications you might have. So that's the third thing is getting your assets. And when you're talking about assets, don't overlook a couple other things. One is your digital assets. So where your emails, your photographs. There's places on Facebook and Google and I think all the social medias where you can pre-name a trusted person that takes over your Google account, takes over your Facebook account when you pass. So that's important to have. You can make pre-designations whether you want to have everything erased or whether you want them to have all of your digital assets. Your passwords. Who has your passwords? Does anybody else? Are they kept in your 3-ring binder, or are they in some sort of an app, or are they just written on sticky notes all around the computer you're looking at right now? So how if you become incapacitated, how is someone going to get into your stuff and help you out? So that's part of the inventory process. And then last, but certainly not least, about inventorying your assets is pets. What pets do you have? Have you considered how they're going to be cared for if you either become incapacitated or pass away? Have you had those conversations with friends or family? So those are just a quick, little summary of some of the things that you need to think about when you are collecting the inventory of your assets. So now I'm going to segue into, well, I call it the things that I recommend you have an attorney help you with. Um, you, some people do these things themselves. They either copy it from somebody else's document or they go online to Susie Orman, Rocket Lawyer, or things like that. I'm going to tell you that I don't think that's a wise thing to do. It's, like I could go on YouTube and figure out how to do open heart surgery, but I'm not going to do that. Or I could go on YouTube to figure out how to change the brakes in my car. Some of you might be really good at that and could do it yourself, but I don't want to run the risk of thinking I did it right, but turns out when I'm going down that hill, it wasn't done right, and now it's too late. And that's where I find people that do things themselves is that we don't know that it's wrong, or we don't know that it's not enforceable, or we don't know that it doesn't actually enforce their wishes until it's too late, until the person is gone. That's why I don't love DIY estate planning. So that's why I call this next part things I would suggest you see a lawyer for, and not just any lawyer. If it's a lawyer that's just going to, charge you $250 to do a will, a power of attorney, and a healthcare surrogate, I would question that. Unless they're asking you all these holistic questions, they're understanding what your long-term care plan is, what's your tax liability, all of these different things that we've just talked about. Unless they're talking to you about all of this and your life insurance and who's your financial advisor if you have one, you're probably not with the most experienced person that you want to be with to put such a vital thing in front of them. So, all right. So the next part of this, I'm going to break up into two sections. One is if you don't have anything in place right now. If you don't have anything in place right now, I would recommend you see an attorney and you have, at a bare minimum, a will, a power of attorney, a living will, and a healthcare surrogate. I'm going to talk about each of those, okay? So a will, a power of attorney, a living will, and a healthcare surrogate. You might need more stuff, but at a minimum, those are the four things that I would recommend. What a will does is it lets you designate, number one, who your executor is. So who's the person that's going to be taking care of these issues when you die? Number two, it lets you say who gets your stuff when you die. And that's very important if you're wanting it to go to someone other than your family. If you don't have anything in writing, Florida law has a plan for you. And the plan is if you don't have a will and you die, if you have a spouse, typically it would go to your spouse. If you don't have a spouse but you have children, would go to children. If you don't have a spouse or children, would go to parents if they're alive. And if none of those siblings, and if no siblings, then it just goes out and to the rest of your next of kin. A lot of my clients, that's not what they want. They might be with long-term partners that they're not married to, and that's who they want to inherit from them. They might be estranged from family, or their family may be estranged from them, and they don't want the family to inherit or to be executor. And that's the default if you don't have something in writing. So that's the first thing that I would suggest putting into place is a will. If you have minor children, the will is also where you designate who you want their guardian to be. The next document is a durable power of attorney for finances. And I will get on my little soapbox and say that, in my opinion, this is the most important document to have because of the significant ramifications it has if you don't have it. So what a durable power of attorney for finances does is it lets someone step into your shoes financially. So think about banking, insurance, IRS, Medicare, Social Security, real estate issues, all of these things that you might need someone to do if you become incapacitated. The power of attorney is only for while you're alive. Once you die, the power of attorney becomes null and void. And the reason why it's important is if you don't have this in place, your loved one, whether it's a family member or a non-family member, would have to go to court and have a judge name somebody to be guardian over you to make these financial decisions. So it's much simpler, much less expensive for you to be proactive and have this power of attorney in place, naming someone you trust versus a judge saying who gets to make those decisions. I had a case once, I don't do guardianships anymore, but I used to. And I had a case where I represented the partner of this couple that had been together for 20 years, but not married. She had dementia, unfortunately. And by the time they wanted to get a power of attorney, it was too late. So he filed for guardianship for her. Well, her family from South Dakota decides they're going to come down and they're going to get guardianship. So we had like a 3-day trial on this. And guess who won? It was the family. The 20-year partner did not win the case. So when I say I'm on my soapbox about a power of attorney, that's why I'm on the power of attorney soapbox, is because this is your opportunity to name someone that you trust to make these decisions for you when you're at your most vulnerable. You've been in a car accident, you've had a stroke, you have dementia, or you've gotten yourself into a position in life where you can no longer make these decisions. Having someone pre-designated is vital. The next document, I'm going to talk about it all together because in my office, we make it into one document, but it's the living will and healthcare surrogate. That's where, one, you get to designate someone to make healthcare decisions for you if you can't make them yourself. And Florida law has a plan for that too. If you don't designate someone, then it's pretty much the same hierarchy as I told you before. Spouse, adult children, parents, siblings. And if that's not who you want to make your medical decisions, if you can't make them yourself, having that healthcare surrogate designation is vital. The other thing the document does is let you decide in advance whether you want to be kept alive artificially. Don't confuse that with a DNR. A do not resuscitate order is a medical document. The living will is a legal document where you say, hey, I don't want to be kept alive artificially if I'm in a coma. I don't want to be kept alive artificially if I've gotten to the point where doctors don't believe there's any medical probability of me recovering. Um, it's important to have that if you have that desire to have that in writing so that it has to be honored by your family. Now, well, I won't go down that road right now. We don't have that much time. Okay. So those are the 3/4 things that at a minimum, I think any quality estate plan would have. Now, there could be other things like someone mentioned a ladybird deed. What a ladybird deed is, it's essentially a way to put a beneficiary on your deed, on your house, so that when you die, the house automatically passes to the person you've put on the deed. Um, it's a great tool. It's not a good tool for everyone, but it is a great tool to be able to avoid probate and potentially avoid Medicaid clawbacks if you've been on Medicaid for any period of time. When I say you might need more, obviously I don't know that until I would meet with a client. My philosophy always is, though, what is the simplest, most cost-effective way we can accomplish your goals? You know, could a trust work for you? Well, it might work for you, but the simpler, less cost-effective thing would be a will, a ladybird deed, and making sure all your bank accounts have pay on death designations. So when I said earlier about going to see an attorney, make sure you see someone that's going to talk to you about all your options and not just put you in a Rolls Royce, win a Honda Civic, maybe just perfect for what you need for your situation. All right. Now we're going to turn to if you already have a plan in place. Okay. Well, you're going to want to review that. We send out cards every year that say, "Hey, you have a plan. Is it still accurate?" Because you want people die, people. I mean, we start to not like or not be as close to some people that maybe we've put in our plan that we want to take out. People, the babies are born. People get married, grandkids are born. So maybe your current plan isn't as relevant as it was 5, 10 years ago when you wrote it. Are the people that you designated, so your executor, your trustee, your power of attorney agent, your medical decision maker, are they still alive? Are they still willing and able to make those decisions for you? If not, then that would be a reason you would want to revise your current plan. Are any of your beneficiaries on or going to be on public benefits like SSI, Medicaid? If so, you probably don't want them to be a beneficiary, or you want to create a more complex plan that lets them have the money without impacting their public benefits. That's something you would want to see a lawyer about. And then again, last but not least is pets. Have you accounted for any new pets that you have? Who's going to care for them? Have you left money for rehoming? That sort of thing. If you have a trust plan, and I do a whole lunch with Liz on trusts if you're curious about those. But if you have a trust plan, has it been funded? And what I mean by that is a lot of people will go to a lawyer or they'll go on Susie Orman or some online program and they'll typey and printy, and they have this stack of papers. If that's all you have, what you have is pretty much a worthless trust because there's nothing in it. Until you've actually funded the trust and retitled assets into the trust, you have what I like to call an empty bucket. We've created the bucket for you, but it's empty. So now when you die, we have to not only probate everything in court, which you were trying to avoid with that trust, but then we have to put everything in the trust through the probate and then go through the trust administration process. So you've actually overcomplicated it and made it more expensive. So if you know anyone out there who has a trust, if you have a trust, if you're thinking about a trust, just know that the piece of paper you get that's the trust is worthless unless you actually put stuff in the trust, retitle your assets in the trust name. And we walk you through all that if it's determined that you would benefit from a trust plan. Let me just check to see if we have any questions. I didn't see any pop up. I didn't see any. So that's probably more than 2 cents. That was probably my 5 cents on some things I suggest you do in 2025 to get organized. There are little things out there on Amazon, like it's called the next of kin box. There's all sorts of little types of things like that give you a full file folder, how to be organized. I mean, that's nice to have, but you don't really need to pay for that as long as you can just think about, well, if I got hit by a bus tomorrow, what would my spouse need? What would my sibling need to know where my things were and what I had? All right, I'm going to go to the questions now. Um, we have a question. I know this might not be related, but a local banker told me I should get a HELOC, which is a home equity loan line of credit, to prevent home title theft. I don't know. That is not my area of expertise. Interesting question, though. I'm not sure how it would prevent home title theft. That's probably a real estate attorney question, though, for sure. Herbass, if you have property in multiple states or other countries, how do you handle estate planning? Great question. So typically, if you have a home in another state and Florida is your home, your resident, typically I would recommend a trust-based plan because we can put that, let's say it's North Carolina, we can put that North Carolina home in your trust and we avoid probate with that North Carolina home. Is if you have a will-based plan and you have a property in another state, you'll have to probate here in Florida and probate in that other state. So you have to do two probates. So that's typically two lawyers, two court cases. The exception to that is, and you heard me talk about that ladybird deed earlier, some other states have similar types of transfer on death deeds. So that's something to explore is if you have property in another state, is it more advisable to do a trust-based plan where we put everything in your bucket, or is it better to have two transfer on death deeds? And the only way to know that is to know what other assets you have and what your goals are. For example, if I have a couple with minor children, well, they're going to want everything in that trust because they're going to be setting out parameters for when their children would inherit, right? They might get some money at 21, some money at 25, or maybe they have a special needs child where they even need to do more planning. So that trust plan would be the better plan. Whereas if you have, adult children and you want them to just have everything outright and everything's fine, then maybe the transfer on death deed is the smarter way. As for other countries, you would have to go to an attorney or notary or however that country works and set up the estate plan for that property in that country. And I know that's important for some people that are thinking of moving out of the country the next year or so, just to know that you would want a U.S. estate plan for your U.S. assets, but a Spanish or, Portuguese plan for those out-of-country assets. I do not do financial planning. My dad wanted me to do that because, moneymaker, but no, I don't do it. I stick in my lane as an estate planning. Next question. Can you repeat the retitle assets into trust? Yeah, absolutely. So I like to think of a trust like a bucket. So we create Liz's bucket, okay? And let's say I own a condo and I have bank accounts, I have investment accounts. Well, I created my trust, typey, and it printed out, and now I have an empty bucket. So to retitle things, I have to go do a new deed to put my condo in the bucket. I have to go to my broker and instead of Liz Moneymaker's brokerage account, it will say Liz Moneymaker Trust brokerage account and whatever else I want in the bucket. And maybe my IRA, now the beneficiary is going to be the bucket, maybe, depending on the situation. Sometimes that's the wisest thing. That's what I mean about funding the bucket. Okay. Um, you can't just have a piece of paper or it's really it's you've spent a lot of money on nothing at all. Next question. I'm a landlord owning three rentals and one primary. I have heard about the Ladybird Trust and LLCs. How do I decide which to do to protect in both the case of my or our death and limit my liability? You know, you're not going to be able to do just one, probably. We typically don't recommend rentals in trusts. You think about your bucket, right? And we put all our personal assets in there, and then you have these rentals. If you put the rentals in the bucket, if there's some issue with the rentals and you get sued, guess what's at risk? Everything in this bucket. So typically we keep those personal assets in the bucket. And then with the rental properties, typically, I don't know your situation exactly, but we typically recommend LLCs for those. And then we assign the interest of the LLC into your bucket. So your trustee can control those, but we're keeping that wall so that you can protect your liability. And then a big thing I am a big believer in is a big old umbrella policy as well. So hopefully that answered your question. For that question, I would talk to an estate planning attorney and probably also a business attorney for the LLCs. Hmm. Okay. How much would your services run me to get all this set up? I do an initial consultation complimentary so that number one, do you like me? Do I like you? Do you have goals that I can help you reach? If not, then I refer you to somebody else. Um, yeah, so my trust plans, I'm going to tell you my start plan for it for a single person is 2,500. But that's going to depend on if you have 47 beneficiaries and sub trusts, then it's going to be more than that. You know what I mean? So it comes down to what's the complications that might be there. Um, all right. So see you soon, Liz. And last questions. One, how were do you put a business in final? Can we work with you in phases? Like will POA living will, and then will you work on the trust if need be? Okay. So Christine, I think the answer to that is it doesn't really make a lot of sense to do a will-based plan if the ultimate goal is a trust-based plan. It's actually going to be more money because well, for me anyway, I'm going to charge you to do this when if we think the trust is the best thing for you, is putting it all in there. And I work with people, we could do half down and half later and stuff like that too. So I have done phases where we'll do the POA and living will stuff first. Like we know that. Let's get that done. And then we worry about the asset protection, the trust, and all that later too. I don't love to do it that way. I like to just take care of everything, making sure that we're like we were talking about earlier, that we've talked about the whole holistic sides of everything, but it can be done that way. Um, So LLCs for each property. Generally, yes, and then an umbrella LLC for all of it, but it's dependent on what your particular situations are. You can also do ladybird deeds for each of the properties. That doesn't have the same liability protection, but it does have the probate avoidance, which is something. Um, okay. All right. Any other questions, even if it is not about 2025? We've got a little bit of time here.
I have a question.
Yeah,
It's
Don.
too much to type. So my grandmother recently passed last year, and my uncle was at first kind of in charge of her while she was alive, and then he tragically passed. And so then her only surviving child received, we jokingly say, custody of her. And so we were able to keep her home until the end. But what we found out was my uncle never filed any of her taxes towards the end of her life. And she did own some real estate that was sold off after her passing. So there's been family discussion. What do we do? Do we file all those back taxes for all those years, or how is that kind of handled?
What does she? I
Well,
may have
I
missed.
no, she wouldn't owe. Well, she would owe the 1 year that she sold everything off.
So when she passed, did she have assets?
She had the assets then; they weren't sold until after her passing.
Um, was there a probate process?
I don't think so.
Okay. Do you know how they were sold without a probate process? No.
You know what? I take that back. They were sold prior
Okay. All
to
right.
her. We knew she was going to be passing
Yeah.
in short form, and so yeah, it was prior.
Yeah. So if she died without anything, I mean, you could go to a CPA and see, but I wouldn't see any reason to do
Okay.
it.
We just
Yeah.
felt like it would be opening up a bucket of worms.
Yeah. I think you would be opening up a bucket
Yeah.
of worms.
Okay. Thank you.
And someone said, "What's an umbrella LLC?" I meant umbrella policy, an umbrella insurance policy. Big proponent of those if you have multiple properties. Um, okay. All right. What's the difference between a healthcare surrogate and a living will? So the healthcare surrogate designation names the person that you want to make your medical decisions if you can't make them yourself. The living will lets you make determination whether you want to be kept alive artificially after two doctors have determined that there's no medical probability of you recovering. So we put all of that into one document, but it's two different things. One is the decision maker after you can't make decisions for yourself, and the other is you making decisions now for a situation that you might be in later. Um, all right. For a trust, can you also manage property for a trust in Connecticut? If you mean me, it depends on the trust language. If it's a current trust, depends on that language. If it's you
I
have
just,
prop, go ahead,
yes,
Christine.
sorry. It's easier. Sorry.
Yeah,
Meaning there's property in Connecticut to put in this trust with you here.
yeah. So I'm not licensed in Connecticut, so usually when that happens, we just if you don't have one, we find an attorney in our network in
Great,
Connecticut to do the deed.
great.
Like do the
Excellent.
deed, not do the deed, but
That's it. Do it
to
all.
to
Thank you.
retitle. Yeah.
I'm really excited. You fired me up. Thank you.
Good seeing you.
You too.
All right. In the hospital hospice question, what would I ask a lawyer or docs needed to protect assets? Um, Peter, I think the better thing to tell you is that I do asset protection consultations for that. And you can find other lawyers that do that as well. That is so uh, dependent on what your assets are. I'll give you a quick Medicaid 101. Um, Medicaid looks at three things. One, do you need skilled care? Two, do you have assets more than $2,000 if you're a single person? And three, do you make more than 2025 numbers? I think it's like 2,800 a month gross, something like that. So those are the cutoffs. There are things that don't count as assets, though. Your homestead property is a non-countable asset. One vehicle is a non-countable asset. Retirement accounts are a non-countable asset. So we would just have to know what your assets are, where they're coming from, and don't let those numbers go, well, then I'm not going to qualify. That's not true. There are ways. This is what I do is to use the tools. They're legal tools to help people qualify for long-term care. Keep in mind, though, that Medicaid only guarantees payment for care for people in skilled nursing homes. So skilled care nursing homes, not assisted living, where you just need a little bit of care. There's no guarantee for any money when it comes to that, or even hospice, and certainly not if you're just in the hospital. So I think I can't really answer your question in any more detail without knowing your specific personal situation. Next question. My late husband failed to list me as a beneficiary on some shares of stock. It took over a year to get the stocks into my name, even though we were married. Don't assume anything when it comes to beneficiaries. Cindy, if I could put that on a t-shirt and have everybody wear it, I would do that because that is a great lesson to learn. Don't make assumptions at all. I had clients that were together 20 years. They never did documents. One of them dies. Guess what? The dead person's family swoops in, takes the house, takes the stuff, and the person's just SOL because they didn't have the documents in place to make sure that each partner was cared for. Very important to have. Jeanette, a homestead property is not counted. Correct. A homestead property is considered a non-countable asset in 99% of the situations when it comes to long-term care Medicaid. I think we're doing a lunch with Liz on Medicaid this year. I'm not sure, but if we're not, maybe we can work that in somewhere. Again, my advice on that is if you're 65 plus and you think Medicaid may be the way that you intend to pay for long-term care, go see a Medicaid asset protection attorney to make sure that you're doing the things you need to do. And by God, please do not gift your house, gift money because you think the government is going to take it, because that is just going to put you in a worse position than you would have been otherwise. The government never takes the money. It just won't cover you for Medicaid. So do not gift as part of your strategy to have the government pay for your long-term care. Yeah, Jeff, I was wondering that about you. All right, last question. The current incoming administration that shall not be named, I added that, and our currently legalized marriage, it feels more important than ever to be supported and protected legally now. I agree. I did a lunch with Liz, which you can find on the website in December, that was totally focused on protection for our community and things that you might want to think about doing. I did not suggest moving out of the country in the lunch with Liz last month, but other things that you can do to ensure that whether you're married or not, to have protections in place for yourself. So, I already have a revocable trust, but appreciate your information. Would I benefit from having you review it? I don't know the answer to that. I do charge for reviewing documents. I would say that if you question, if you have doubts that it's what you want or that it is funded correctly, then maybe it's worth the $350 it would cost me to review it. I don't like, no, I'm not saying you're doing this at all. I'm like, I don't like to usurp another lawyer's lane. So if you have another lawyer that you're working with, then definitely I would suggest you go back to that person and just make sure, because they should be doing that for you for free. Do I have an opinion on insurance plans, annuities that have long-term care riders? I think they can be excellent, but I think again, it's a holistic approach, right? What are your other assets? What are your other options to pay for long-term care? If you're funding this rider, are you taking from some other pot of money that you might need? So that's a discussion that we would have with your advisor if you have a financial advisor because they run those numbers, and then we can have an educated discussion about, well, does that really make sense for you? Okay. All right. That is all I have. I'm going to stick on in case you have any other questions. I really appreciate you being here. This has been good, a lot of good questions. If you think of something that you forgot to ask, or again, you were too shy, you can just give us a an email and we'll do the best we can. I don't give legal advice via email, especially to non clients. But if it's just a general question, I'm happy to answer that for you. Our office is in St. Petersburg. Oh, yeah, okay. In 3833 Central, in St. Petersburg. So just west of 34th Street. Um, yeah. So I've seen revocable and irrevocable trusts. What's the difference? Well, there's a lot of different types of revocable trusts and a lot of different types of irrevocable trusts. But the easiest way to think about it is a revocable trust is a bucket with an open top. I can take things out of it. I can put stuff into it. I can change the instructions on the outside of the bucket. It's revocable, it's living, it's changeable, right? Irrevocable, I'm putting a lid on the bucket and a lock on it, and I'm throwing away the key, essentially. So once it's done, the assets are there. They can't be taken out. Nothing can be put in there. And we can't change the terms of the instructions on the outside of the bucket. That's an oversimplification. So if any lawyer watches this video later, don't shoot me. But that's the easiest way to kind of explain the difference. And Lynn, yes, we are recording it. We kind of missed the very beginning of the recording when I was just doing my introductions, but all the substantive stuff is there. So, all right, if I'm sticking on, if you think of anything else, Jeanette, only depends on the language of the trust as to who can change the revocable, but typically the person that created the trust has the authority to amend it, to change it, but that language would be in your trust. Bye, Jeff. Jamie, I would say it's best to make them revocable because you can always make them irrevocable later if you need to. The only reason you would want to make them irrevocable is if you needed it for Medicaid planning. But anytime that we need it and we have a revocable plan, we just go back and make it irrevocable. And the reason I say that is you might change your mind. You might move to, you know, Washington State or something, and now you've changed it, or you got married to someone who has a plot somewhere else. So I think it's always good to give yourself options to get out of things. So, yes. So revocable can be changed. It can either be amended. And I would say that most lawyers, including myself, do not amend trusts we do not write, that we did not write. I have a few exceptions for a few attorneys that I know their product, but typically your amendment would have to be done by the attorney who wrote it. What you can do if you go to a new attorney, though, is we can do what we call a restatement of the trust. So we keep the same name, the same original date. We're just essentially peeling off the sticker of instructions on your bucket, and we're putting a new set of instructions on there. So you would sign a whole new trust. Okay. Take a drink of water while I see if anyone has any other questions. All right. Well, thank you all. Have simpler to change an irrevocable then. No, you can't change an irrevocable. Remember, irrevocable has the lid with the lock and the keys thrown away. The revocable is the only one that you can change. Right. Yes. All right. All right. Well, I hope to see you on another lunch with Liz soon, or, give us a call if you want to come in and have a complimentary consultation with us. We do those in the office as well as Zoom. We Zoom all over the state. If you have friends and family outside of the area, I'd be happy to service them. Appreciate y'all being here. Have a great January and stay warm. I'm going to hold you to it, Christine. I expect to see you soon. All right. Juana, thank you for sharing our social media stuff.